Hello, everyone. Welcome to today's Learn at Lunch. Today, we're going to be going over some interesting record requests, specifically some case studies that have been litigated and won or lost. And I put this into an interactive format for you all to answer questions as you see fit. Here's the catch. So as you see the question in the chat to Christy, put your answer. If you get a majority of these right, we'll shoot you over a scratcher's ticket. So really excited about this. I see there's a lot of experience with us today, but there's also a diverse group of you. Some of you have only been managers for a little while, and others have been managers or executives for a very long time. So my goal here is to not only give you your CMCA credit, but to make sure that each of you walk away having learned something. At the end, I'll leave it open for Q&A. So if you can stump me, you'll win $1 billion. Hopefully, we'll get just Mega Millions, I think. Is that what it is, Christy, that we'll get them if they can stump me? Anyways, all right, very good. Well, let's get started. First of all, I'm Clint. If you haven't ever met me before, with Goodman Holmgren, I'm the managing partner here. And I love HOA law. It's always something new, always something interesting. We all have to deal with crazy homeowners, sometimes crazy board members, but that's why we're in it. It's a high octane profession, and I love it. So first of all, because this is a CMCA approved course, I have to give you a little bit of background before we dive into the exciting parts. But basically, by the end of this session, you will know what association records are for the most part, and how to deal with record requests. And hopefully you'll walk away with a few case studies of some of these weird ones the judges have already handled for us. All right, first of all, when you're dealing with record requests, there's the main statute, and it's this link here. I'm going to go to my website because some of you know about this, but some of you may not. And it's the statute search. So if you go to my main website, you can click on statutes. And we're in Arizona for this class. So if I want to type in association records, and then let's say I'm talking about a planned community, I want to search the statutes for that. It pulls up all of the records request statutes. The specific one we're going to talk about today is this one right here, 1805. This statute search tool is awesome. So that's my sales plug for the day. Use the statute search. If you like it, shout us a quick like. If you have suggestions on how we can improve it, please let me know, because this was developed based on manager feedback, and we continue to develop it based on your feedback. So that's really important to me. So if you were to click here, this will take you right to the statute. This is pretty small text, so we're going to jump back now to my PowerPoint to go over these statutes. First of all, a record. We want to turn to the Nonprofit Corporation Act to determine what a record is. There's several of them. We know there are, and these are kept as permanent records, which are minutes of the association, your governing documents like your CC&Rs, your articles, your bylaws, those sorts of things. Your accounting records, tax returns, financial statements, all of those things are association records. And so there are a few other things as well. But in this world, what's permitted with paperless? If we're going paperless, what can we keep? What can we destroy? What should be disclosed? What should not be? So again, the statute does talk a little bit about stuff. We just talked about some of these resolutions, minutes, written communications. A lot of these now you have in the homeowner portals, which is great. It's electronic. It's available for the homeowners. And so there's some timeframes as well. Now, I admit this is really basic stuff, which is why I'm going just speeding through this to get through to our case studies. So please bear with me. If you are one of those managers that are just now starting, or you're a board member that's trying to figure out what actually is a record, I'm going into this mostly with the understanding that most of you know what basic records are, but just the key rules here to keep in mind. The records requests deal with governing documents, financial statements, minutes of the association. Okay, those are the main ones. Sometimes they want invoices from vendors. Those too are records. Sometimes they want invoices of attorneys. Those too are records, but portions of those invoices, or all of it potentially, can be withheld. The safest thing to do is just to redact all of the details of what is being said in those attorney invoices, because that's attorney-client privileged information. And then disclose the actual totals charged. But even then, some judges are okay with holding that, which we'll talk about later on. Okay, so here's another portion of the statute. This is all in the written materials if you want to look over it again. And it just basically says, again, all financial or other records of the association shall be available by an owner for inspection or by their designated representative. And the association has 10 business days to fulfill these requests. And they have 10 business days to get them copies if the request was for copies. The bigger question under this, I'll just sprinkle in a little bit right now before we dive into the case studies. The question for this one is, well, what happens if all this stuff's already on the homeowner portal? Do we have to disclose that information to the homeowners again if they can just go into their portal and grab it? So what do you think? Do you think you have to disclose it? I don't think you do, and I think most judges agree with me. In fact, we had a case that we had to litigate this about 5 years ago, where the argument was that the association violated these statutes. This was before the DRE, by the way. The argument, just before the DRE, the argument was the association violated the statute because they refused to provide the records that they were requesting. In that request, they requested all the governing documents, the CC&Rs, the articles, the bylaws. They requested all the open minutes from open board meetings. They requested all the annual, and I'm saying all from the beginning of time, all annual minutes. And they also requested the last 5 years of financials. And guess where all of that information was? It was in their portal. And they had access to it because the management company, could see when they'd log in, when they'd log out, where they'd go, where they wouldn't within their portal. And so the management company's response to the homeowner was, it's in your portal. And they even provided screenshots of how to access it all. That homeowner then sued in Superior Court, saying that the association violated the statute by not actually physically providing copies. The end result in that case was that the association complied with its duties because the association had provided the outlet for it and could establish that the individual knew exactly where it was at. All they had to do was click on it to download it. So the court dismissed that homeowner's case. No adverse ruling against the association. The only caveat with that one is that it didn't go to the Court of Appeals. So we don't have this in case law yet, but that's the majority view that I'm seeing. So I think you're safe if you've got the portal and you can just direct them there. That's the legal answer. Sometimes you may want to give them the documents anyways, but we can talk about that later offline if you have specific questions about that. Okay, so let's talk about briefly, before we get into these case studies, some of the specific exempt items. Number one, anything related to a communication with your attorney. And like I said before, that's invoices with all the details in there. The state bar likes it when we put lots of details into our invoice we're getting you. Names, exactly what we're doing, who we spoke with, when we spoke with them. All of that information typically can be attorney-client privilege. So I don't think it's a good idea for the board to give attorney-client privileged information to owners, as do most other attorneys. So if a homeowner is requesting a copy of an invoice from the attorney or a bunch of them, if you are going to give them to them, I'd say redact all of the attorney-client privileged details in those invoices. Pending litigation, anything related to pending litigation. If they want to know what's going on in a case, they could technically send their own process server to the courthouse to grab documents, but we don't have to give anything to them if it deals with pending. Another one, and these are all basic. So for you people with lots of experience, hold your horses. We'll be right there with some really crazy questions and answers here in a minute. Meeting minutes of executive meetings. That's executive. You don't have to give those out to the members, and we don't recommend you ever give them out. Executive minutes should be kept closed. Anything related to personal information, financial records, or health. So if a neighbor is pissed because their next door neighbor is parking on the street in front of their house with a handicap equipped van, and they got an ADA or an FHA exemption because of it, you don't have to prove to that neighbor and provide records of the disability of their neighbor. That would be a big problem. This goes also for delinquency reports, ledgers, violation history, you name it. That's personal. Number 5, anything related to job performance, compensation, health records of employees. Okay. As far as the associations not being required to disclose financial or other records, here's the catch-all as well under subsection C. You're not required to disclose anything outside of even those 5 things if disclosure would violate any other type of state or federal law. So if you have a settlement agreement that's confidential and they're demanding a copy of a settlement agreement that's confidential, that would be a violation of state law to disclose that. Keep it quiet. There's lots of other examples that could violate state or federal law if you engage in disclosure. What happens if you're engaged in an audit with the IRS and your tax attorney or your accountant says, hey, do not disclose this. Rely on your expert's advice. So if you ever come across a situation where you think you may have a state or federal law issue, let us know. But those 2 are probably the most prevalent examples that we see in this space applying subsection C. All righty. Again, who can request these records? The owners and the designated representatives. Those are the 2 main ones that can request records, because that's clearly what the statute says. What about the attorney for the owner? Can they request these records? So the answer is yes, we get those requests all the time. You've probably seen them, and we comply with them because we treat them as the owner, essentially. We don't treat them as a designated representative. That's more for people going in somebody else's place, almost like a proxy. They're just not voting. They're just sitting there on the owner's behalf. An attorney is an advocate for the owner, which is different than a designated representative. But under most laws, you treat an attorney as if they're the owner. So we respond to attorneys and record requests. There are times where we will tell the attorney, no, we are not responding to this request. And interestingly enough, one of them is going to be a case study we're going to talk about in just a minute. So I don't want to give too much away. Here's a few examples of personal information for those of you who are just getting into this space. Documents related to a closing, social security numbers, telephone numbers, email addresses, a lease agreement. A lease mostly for probably your commercial properties, but those are, I don't know why lease is on there actually. Disregard me saying lease. But social security numbers, telephone numbers, ledgers of homeowners, we talked about that. Email addresses is another one that's a big question. What about the email address of a director? Is that something that must be disclosed to somebody that's requesting it? So then they can, or an email, all of the email addresses of all of the members in the community. It's a great question, right? You get these questions about membership lists and whether you have to disclose the entire membership list. The majority view is no. Emails, so phone numbers, those are personal information of homeowners. And besides, we don't want that individual making that request to start harassing homeowners. So we treat most emails as personal information. And we're getting traction in the courts that the judges agree with us typically. On membership lists, if you provide those, if there's a way your software can to remove the personal information and just disclose the name of the owner and their lot number, that's fine. If they want to go to the assessor and pull up actual addresses and then find out if they can find emails from there, they can do that in the public domain. But that's not on you. That's not your requirement. All right, now we're into the scenarios. If you have any questions, go ahead and put your question in the chat for me. I'm going to be monitoring chat periodically as I do this, but I see a couple of questions here. Let's go through these before we get into scenario one. Under financial records, are there any specific definitions for that? For example, would a bank statement be required to be included and retained by the HOA or just financial reports? That's a great question, Veda. There are some specific things the statute mentions, but then the one you saw is only financial records. So I don't believe there's a specific definition that describes each and every financial record. What we typically advise our boards to do is to adopt a records resolution that does define the specific records. And I think a lot of you do that. So if you don't, that's a great way for you to ensure that you've got a clean record of what's financial, what's not, and work with your attorney. We'd love to do it with you on what those are, so that you know exactly what you have to keep and what you can disregard. Do all the documents have to be on a secured site, meaning one you have to log into? It's a good question. I've seen HOAs, boards put their records in portals that are in the public domain. They have their own website, typically self-managed. I don't think that's a good idea for two main reasons. Number one, these are corporation records. They're not public records. You wouldn't see Apple posting all of their records online for anyone to see, or any other corporation for that matter. Some things are public, especially if you're publicly traded. Sorry, kind of disappeared there for a second. But these are private corporation records of a nonprofit corporation. So I do not like seeing records in the public domain, because especially like if you want the homeowners to keep stuff between themselves only, you don't want those records in the public domain. But even if you do have some of these documents in the public domain, don't put your executive stuff in the public domain. That should be private, where even the owners can't access that stuff, like your executive minutes and those kinds of things. Your attorney opinions, I would not put those on a public domain in a public website. Emily asks, is this only for homeowners? What about potential homeowners or realtors? Do we need to provide documents to them? That's a great question. So again, the two main people that can request records are homeowners or their designated representatives. Could a realtor be a designated representative? Yes, it could, if the owner designates them as their representative. Is it a potential buyer? No, they're not an owner. Is it a friend of the owner? No, unless they're designated by the owner as the representative, they're not entitled to records. Okay, very good. There's a couple more questions, but let's get into this scenario. Here's the question. An owner requests his neighbor's architecture review application and approval. These are going to start easy and they're going to get a little more challenging. What do you think? Answer this question straight to Christy, and we'll see if you get it right. So I demand my neighbor's approved application from the architecture review committee. You need to give it to me. What's the answer? The answer is it depends. It depends on if this was an application that was decided in an executive setting or if it's an open setting. Now, the statute just a couple of years ago changed to require architecture review committee meetings to be in an open meeting if they are regularly scheduled. So obviously, if you're doing everything in open, it's an open record. So yeah, those would be open if you did all this in an open meeting where members were present. If, however, this was an ad hoc committee decision and there was no openness to it, then there's a very good argument that these are executive privileged, not privileged, I'm sorry, just executive information, executive records that do not need to be disclosed. So we don't have case law on this. And I've heard some attorneys argue that you have to give ARC applications no matter what. But I think the majority view is that because the statute is very clear on what's open versus closed when it comes to ARC meetings, then obviously the records related to whether it's an open or closed apply in that records analysis. So if you make this without the members, you can keep those records confidential. So that's why we put thumbs up, thumbs down, because it depends. Scenario number 2. Move my screen around a little bit. A former director, past president, calls you and wants all of the emails you sent to her when she was on the board because her computer recently crashed and she no longer has it. These are real examples that we came up with, or that we gathered from our records, from our own files. What do? Do you have to give this past president all of the records, including executive records, that she had access to when she was on the board? So what's the answer? No, you do not need to give that past director these records. In fact, you should not give that past director all of those records. Why? She is a former director, and because she's not a current director, she's not entitled to those records. In fact, yes, like I'm on my board. If I leave my board, yes, there's records available, but I have a continuing obligation to keep those records confidential and not just disclose them. Just because I'm no longer on a board doesn't mean my duties of confidentiality goes away. My fiduciary duties to the corporation survive. But if she doesn't have access to them anymore, she's not making the request as a director. She's making the requests as a former director, or i.e. an owner. All right. What would you do? This is a little bit of a big one with a lot of minutia on these 1, 2, 3, 4, 5, and 6, but they're interesting. So let's talk about this. When you receive a letter from an owner's attorney with the following requests for records. So which ones of these do you have to provide and which ones do you not have to provide? Number 1, all meeting minutes, meeting notices, and correspondence by the board of directors approving new paint schemes, design guidelines, and other changes implemented by the board. So these go to really like the rules and resolutions of the board. Do you have to disclose those? Yes or no? Number 2, we're going to switch slides in a minute here where it gives us the answers. Number 2, contracts the community holds for landscape maintenance, pool maintenance, gate maintenance, property management, and other contracts signed by the board between March 2020 through February 2021. So all of the vendor contracts, we'll call them, is number 2. Do you have to disclose those? Number 3, the list of violations issued to owners from November 2020 to March 2021. By the way, this is a cut and paste from a demand letter we got from an attorney. So do you have to disclose number 3? The list of violations issued to owners from November? blah, blah, blah. Number 4, copies of the reserve study from 2013 to present. And then number 5, March 2021 financial statements, subject to approval by the board and audit. And number 6, annual meeting agendas and minutes from 2013 to 2018. Now I see some more questions popping up in the chat as I'm talking. We'll try to get to some of them. If I do not get to your question, I would love to answer it. And most of you asking these questions know exactly where I'm at. So please reach out to me either via text or email, and I'll respond to each of your questions, or I'll call you and we can go through things if I can't get to your questions today, okay?
And when you're answering these questions, make sure you're sending those in a direct chat to me, Christy Gill, that's Guell. Thank you.
Perfect. So the everyone will be the questions for the Q&A more like, but if you're answering, just do it to Christy Guell, Guell. So number 1, all meeting minutes, meeting notices, correspondence. Yep, check. Those are corporate records. Those need to be provided. Number 2, yep, these are corporate records and they should be provided. Those are all the vendor contracts, right? So far, so good. But here's the part you need to be concerned about. Other contracts signed by the board between March and February 2021. We don't know what they're talking about. Is it justifiable for us to go back to the attorney and say, be specific? Yeah, absolutely. That attorney was very specific with the first set. They need to be more specific for us. Or sometimes we'll just, if we already know banker box, there's a banker box of nothing but invoices and contracts of vendors. We might tell them to come in and inspect everything and then let us know what copies they want to make. But if we're only engaged in a back and forth with providing copies with no inspection involved, they need to be much more specific for us. And we can deny that. We've been able to deny this, by the way, for decades. Not necessarily as a records request before litigation, but in litigation when attorneys are making records requests, because we've been doing this since the beginning of time, that you have to be very specific. And the court rules require you to identify the specific records that they want. So that same standard applies for you and for me here when we get these types of requests. No, list of violations not open to the members. That's personal information. Reserve study conducted from 2013 to present. Yeah, but notice there's an exclamation mark next to this. Why? What if they want the draft that the board has not approved yet? Is that an association record? Things that the board has not approved yet arguably are not association records. So what about draft minute? That leads me to the next question. What about draft minutes that have not been reviewed and approved by the association yet? Is that an association record? No, it is a draft. The board has not approved those minutes yet. Once the board approves the minutes, then absolutely they're association records. But up to that point as drafts, they're not considered, quote, association records, end quote. Number 5, the financial statements. Yes, absolutely. And annual minutes. Yes, absolutely. These are annual member meeting minutes. It's open. So yes, absolutely. We put in here in the written materials as well, the accompanying nonprofit corporation statute that says it is an association record. And then obviously we just talked about whether it's disclosable or not. All right, let's up the level of difficulty a little bit, shall we? Scenario number 4, what should you do? The HOA has an election and everyone votes via secret ballot per a rule in the documents, not the bylaws, not the articles, a rule. Just so you know, if you're wondering if that a rule is valid to incorporate secret ballots, the answer is yes. The statute says in the Planned Communities Act, if secret ballots can be used if they're authorized by, quote, the community documents, end quote. And the definitions are obviously everything we know of: declaration, articles, bylaws, and rules. That's the definition of community documents. The same thing's true in the Condominium Act. It says condominium documents, and rules are part of condominium documents. So, side note, secret ballot can be a requirement per rule, not just the articles or bylaws. So anyways, going back to the scenario, HOA has this election via secret ballot. There's an upset owner. This owner did not like the results because they were not elected. And there's gotta be some shenanigans because they weren't elected. Number 3, the HOA. Here's what the HOA does. They would not give the owner the voting records until he signs an NDA, non-disclosure agreement. So let's make sure we're clear here. Owner demands all the voting records. Are they entitled to voting records? Yes, they are. The bigger question here is the association requires they sign a non-disclosure agreement that essentially says, okay, we've got the records, you can come grab them, or we'll give them to you via email, but you can't be posting these to anyone outside of the corporation. You can't put them online. You can't send them to the media. These are corporate records. They're private. You cannot disclose them outside of the corporation. He refuses to sign, and so the HOA says, okay, we're not giving them to you. Is that a violation of the records disclosure law? Real quick on this NDA piece, Robert just asked, do we have to offer the NDA? No, you don't have to offer an NDA. This community just wanted to do it because of the history of this particular individual. Really nasty individual. This happens to be a community we represented. So yeah, it's I know the history of this particular individual. Very nice person. So they but they didn't come to me for that question from the NDA. Here we go. If you answer the question, there's no violation, you're right, according to the Department of Real Estate. Per the Department of Real Estate, there was no violation. And by the way, if you want to look at that case, on each of these where these are actual Department of Real Estate cases, I give you on the lower left-hand corner the actual case number with the judge. Judge Jenna Clark was fantastic on this one. No violation of the records law. Okay, here we go with number 5. What would you do? Oh, I'm sorry. Somebody wants to know what voting records are. The ballots that were used, because this was secret voting, the envelopes. Oh, this would just be anything, I think, if you're returning them. Envelopes, ballots, especially in secret ballot voting, because envelopes have to be signed, dated, and everything else when they're returned. Tally sheets, the list that shows the who's eligible to vote and who's not, that you keep when you're checking people in, checking them out. Those are all considered standard voting documents. Pieces of those may be redacted. Let's say your check-in sheet has like an email next to the homeowner's name. That might be redacted, but that's a vote. Those are voting records. Okay. Scenario 5, what would you do? You've got an upset owner, sues the HOA about a short-term amendment to the CC&Rs. So she's basically renting out her unit on Airbnb, and the HOA board and members amend the CC&Rs to prohibit that. This is pre-Supreme Court case, by the way, that Cowway case some of you are aware of. This is a case that happened before Cowway came down. So up to that point, short-term rental amendments were totally valid. That wasn't the issue in this case. The issue in this case is she's pissed. She demands the HOA provided with all the documents about a keyless entry program. Now, this is what she demands in the middle of the lawsuit. So on the one hand, she's suing the HOA over the short-term rental amendment. On the other hand, outside of that lawsuit, she goes, oh, give me all these documents about your keyless entry program. And the HOA says, nope, we're not giving you anything. And their response when she lawyers up was, their response to the lawyer was, you're just trying to backdoor the litigation process in your other lawsuit. You're trying to get a bunch of records that aren't otherwise available to you in that lawsuit. And then you're trying to use those same records by using this records statute to somehow backdoor the current litigation. So the answer is, does the association have to provide these documents? And just presume that what she's requesting are actual documents, association records, okay? Because we're not going to get into whether those are records about the keyless entry program. Just assume that they are. Go ahead and text Chris your answer, or not text her, sorry, you don't have her cell phone, but just send her the chat. Here we go. Nope. The HOA was permitted to withhold the documents because they were relevant to the lawsuit. Interesting, right? Judge Thompson in this one was pretty clear that you cannot backdoor a pending case governed by its own set of rules of civil procedure to grab documents by using some other statute. So that's what Judge Thompson ruled. Admittedly, perhaps another judge could rule differently. And these are case studies from the Department of Real Estate. We're not talking about the Court of Appeals, for example. But these are consistent rulings from what we're seeing from the Department of Real Estate. And chances are, if somebody thinks that you violated the open record statutes, chances are they're going to go to the Department of Real Estate. They're not going to sue you in Superior Court. So this is a great tool for us. Bottom line is, this is the position of Judge Thompson in the DRE. And we're seeing consistent rulings with other judges as well. Trying to backdoor the litigation process does not make judges happy. All right. In fact, I put this in parentheses, not sure why she didn't demand those documents in her lawsuit, because she probably would have gotten them if she had simply requested them through what we call request for production and non-uniform interrogatories. Those are the legal terms of disclosure, discovery rules and titles that we call if you want documents in litigation. So there you have it. That's that scenario. Scenario number 6. What would you do? A board member demands the HOA get him a ton of stuff. We wanted to keep this one simple, so we're just going to say everything, ton of things. The HOA gave him what he thinks is only about 5% of his records. So he's saying, give me all the vendor contracts from the beginning of time, give me all the minutes, give me all of the invoices from the landscaper, give me, and so on and so on and so on and so on. You see these requests, right? If you've been in this industry for any amount of time, or if you've been a board member for any amount of time, you've seen these types of requests, or just tons of stuff. And when you provide it, they're like, oh, this isn't everything. You hear that response a lot too. He also claimed the information he got was forged because it contained the name of a different association. So in the records that were provided through no fault of the management company, I think in the transfer from one management company to another, a couple of other records from another association were put in electronically into this particular community, which can happen, right? Especially when you're dealing with paperless records. And so he thought the whole thing was forged and a fraud because a couple of these documents had different names. So he sues in the Department of Real Estate. The question is, did he win? I mean, he thinks he only got 5%. Now, the board member did not present. Oh, by the way, that individual wasn't actually like a board member, a rogue board member. The board member did not present any credible evidence that the HOA withheld documents. Admittedly, maybe they did. I don't know. But the board member, this rogue director, I'm going to call him, had the duty to present evidence to the judge in this DRE case that they did not disclose all the records. He couldn't do it. So Judge Clark says, no, there's no violation. Tough luck. Bye. By the way, if you get these massive requests and you do have to provide like hundreds of pages of documents, you do get to charge them the statutory rate of 15 cents a page. And there's a couple of different ways to handle that. You could just put a bunch of banker boxes out in the conference room and let them go through everything and then make the request for certain copies. I think that satisfies the statute. In fact, there's another case that says it does. Even if they're wanting copies, you can say, we've got all the records for you. Come on down, take a look, and tell us what you want copied. Scenario number 7. What would you do? Another one. Here we go. An angry owner demands the HOA provider with voting records. This is kind of like the same thing, right? We just covered in the last couple scenarios ago. So demands that they provide her with all the voting records in a community with secret ballot requirements. The HOA first requests the owner sign an NDA. The HOA did get then this is another meeting, by the way, a couple years later. The HOA did give her redacted voting records, and for whatever reason, it would just pass that 10-day deadline. Once she received those records, slightly redacted, she makes another request for all of those voting records being unredacted. And then the HOA said, no, you can't have them. You can't have unredacted. You've got the redacted ones. You can't have the unredacted ones. Now, remember, this was secret ballots. So you've got a set of ballots that don't have any information of homeowners on it. And then you have envelopes on the other end that have their signatures, lot numbers, and dates on them. That was all provided along with the tally sheets. But on the tally sheets, there was some stuff that was redacted because this lady didn't, some of the people were worried about getting sued by this litigious individual. So HOA refuses to give her unredacted records. Violation? Nope. Judge Stone. So here's another judge of the DRE saying, no violation. The requirement to sign the NDA, number 1, does not violate the record statute. So now you have two judges, Judge Thompson and Judge Stone, saying NDAs do not violate the statute. But yes, the HOA was slightly late in getting the first round, but not the second response. And the HOA's refusal to provide unredacted voting records was okay because she didn't sign the NDA. And the owner refused to pay for the records in any event. So that brings up another topic. In this community, they said, all right, we've got some of this stuff, but there's 2 requirements. Number 1, you need to sign the NDA if you're wanting unredacted stuff. And number 2, you need to pay the 15 cents per page. And you need to bring a check with you when you come to grab the copies. And she said, no, I'm not going to bring the check with me. And Judge Stone found that was sufficient to basically say there's no violation. I don't think that was the main reason, because you can see here, the Judge Stone is also saying the NDA is not a violation. She just simply had to sign the NDA and bring the freaking check for the money. But it was clear from that ruling that Judge Stone mentioned that she didn't she refused to pay the records anyways. So according to Stone, if you want, you can tell the owner, okay, we've got the records, bring your check for the 15 cents per page. And if they refuse to do that, arguably that's not a violation. Again, the caveat here is this is the Department of Real Estate where most of these are being handled. We don't have case law yet, nor do I think we ever really will on these things. But this is setting a precedent for us, a very good precedent for associations on how to handle these weird requests and what you can do to both protect the board and protect the HOA and protect the management company. The question was really, and here's one that came up, if she had signed the NDA, could she have gotten the unredacted records? And I would say yes. It was pretty clear to me that if she had signed the NDA and the association refused to give her the records at that point, it would have been a bait and switch scenario. The HOA was saying, we have the records for you. You just need to sign the NDA. If she had signed the NDA, then they say, oh, we changed our mind. The judge isn't going to be happy with that. So if you're going to require them to sign an NDA for the records, make sure you give them the records afterwards. Don't use it as a bait and switch. Okay. All right. So that concludes some of these interesting questions. I try to keep these classes nice and short. So now I want you to stump me. If you can stump me, you get a Mega Millions or whatever it is for Powerball ticket and potential chance to win these billions of dollars. So I'm going to look through the chat now on these questions. And if you've got a question about a specific records request question, put it in the chat for everyone and we'll take a look. I'm going to skip over any questions specific to what was asked as part of this presentation and just go straight to records questions. All right, here's one. What about lenders when they ask for open meeting minutes and other items because they aren't happy with what was answered on a condo questionnaire? Well, number one, the lender is not an owner under the statute. If the lender was a written designated representative, perhaps, but generally speaking, they are not. I think this question was asked more about like what lenders are requiring for inspections and things and like actual statements you're giving them at closing now. Some of these underwriters are saying you have to like certify this place doesn't have any kind of structural defects and there's no known problem with the structural nature of the community because they don't want to have another condo collapse like happened in Florida. But you don't treat them like owners and under records requests. There's no obligation for you to do things. And condo certs and others have great disclaimer statements already from what I've seen. If you have questions about what you have to disclose to them, if they're wanting a disclosure itself about the structural conditions of the community, reach out to me and we can talk about what you're providing, if anything. Here's one. What if it's not an attorney that's requesting records, but it's a company owner requesting violations from over a year ago for a tenant? I'm gonna presume this company owner is like the owner or a member of the LLC that owns the property. And they're requesting the violation letters that they received, their LLC received. Absolutely give those to them. You have to, it's their records, especially if they're a member of the LLC. The bigger question is what happens when somebody that claims to be part of the LLC demands records, but you don't see them on the corporation commission as a member of the LLC. Or maybe it's a Wyoming LLC, and under Wyoming law, you can never find who the members are of that LLC. How do you confirm or how do you know whether the person making the request is an owner or should be considered and treated as an owner? There are a couple of ways to do that. You can demand that they provide the operating agreement. You can get a statement from an attorney that claims to represent the LLC and a few others. This is a very rare scenario. If you ever have it come up, reach out to me direct, because it is on a case-by-case basis, depending on the state where you're looking. But because normally these are all Arizona LLCs. If it's an Arizona LLC and somebody that's not a member is making the request and you see they're not a member, you reach back out and say, hey, I see you're not a member. Can you please get me some affirmation from the members saying that you are their designated representative? And then you're good to go. Here's an interesting one when it comes to voting, like voting records. So we talked about envelopes. What happens when somebody mails back their vote in an envelope for a CC&R amendment? Do you have to save the envelopes along with the actual written consent form that was sent back, or the absentee ballot, whatever it might be? The answer is it depends, I think. It depends. Even if you do, you only have to keep it for 1 year under the statute. So even assuming the envelopes are considered voting records, if people are voting via secret ballot, I don't typically see secret ballots on CC&R amendments. But if they are voting via secret ballot, you've got to make sure you keep those envelopes. Those are essential, absolutely essential. But I can't remember the last time my firm had a board ask us to put together ballots, absentee ballots, for a CC&R amendment with secret ballots. I don't know if any of you have seen that, but usually I see all the identifying marks on any CC&R amendment, and as voting materials, those are important. Does any violation information need to be disclosed in a list of violations with the homeowner redacted, dates violations sent? I'm not entirely sure what you mean, Mark, with this question, but I'm just going to restate what I think you mean. So a homeowner demands a violation, all the violation information, with the list of all the violations, but the homeowner's redacted. So let's say you sent out a violation letter to a neighbor, and they for RV parking, and they, for whatever reason, think that there's a ton of other RVs and they're the only ones you're picking on. So they respond to you and they say, I want a list of all the violations that you sent out for all the other members in the community, and I need that now. And so your question now is, do you have to provide those records, but with the homeowner's name redacted? And the answer is, I think with your software specifically, there's ways to produce violation history reports without the owner information in it or the dates. So really they just see a bunch of violation history letters sent out, but they have no idea who they went to and when. I don't think that is classified as a record technically. And I don't know if you have that duty based on the trends we're seeing in the Department of Real Estate. I would imagine most of you were very surprised to see how the judges were ruling on these recent cases, with how much they're ruling in favor of the association. I mean, I think it was 100% HOA that we saw. So I think the argument here is those are personal. That's personal information. That's the starting point. If the board wants to bend over backwards for somebody, then possibly. And by the way, if it's in litigation, there's different standards for litigation. We're only talking about a records request in the pre-litigation context. I'm not so sure that you're obligated to provide them with the violation reports, even if the owner information is redacted. If you can do it, I don't see the harm in doing it, but I don't think it's an obligation. Here's one. Can owners go to the management company and go through all documents without management watching the owner? The documents do not involve executive information. So in other words, when the owner shows up to inspect everything, and a manager walks in to sit down and observe, can the owner say, oh, you have to remove yourself, we're going to do this in secret? The answer to that is no, the manager can do that. In fact, a lot of times they require the attorney to be in there in these scenarios. Now, that's, some boards don't want to do it because they don't want to pay the money, but if the management company does it, there's no requirement that they have to do it in secret. That has never been contemplated by the statute. I actually like the idea of an observer in the room, especially if that observer is looking through a box before they, if the owner is going through one box that was already pre-screened by the manager to make sure there weren't any executive information in there. And then while they're doing that and they're going through that box, the manager's going through another box, or just sitting there watching them. That's fine with me. There's nothing that prohibits that. Is any email between a manager and a board member considered a document to provide when requested? P.S. There is no official action being discussed. Lori, this is a fantastic question. Let me go back to the Department of Real Estate again. This is a DRE decision from about 6 years ago. Just when the first DRE came up, before it was deemed unconstitutional, and then it came back a second time. I can say that to you because you've been in the industry long enough to remember that. So in the first go around, the DRE had a case come before it where the board was chatting via email to help prepare for the upcoming open board meeting. And in that chat, they were asking each other about the scope of the landscape contract that they were going to be reviewing, or whatever it was. It was a vendor contract. And so after a little bit of back and forth via email, the manager's directions were clear. So the manager went out and revised the contract, got it ready, and then they set the open meeting. In the open meeting, the board approves the contract, and a homeowner in attendance was really pissed that the contract was much different than the prior board meeting because of these emails in between the meetings. And so they sued and said, well, first of all, they demanded all the emails, and then they sued because the emails weren't given to them. The Department of Real Estate held that those were not the board association records because there was no decision made. Same community, different DRE matter. The next one was the board did do an action in lieu with unanimous written consent via email. And then then they ratified that in an open meeting a month later when they had the regularly scheduled meeting. Same homeowner in attendance, same community, was pissed that they ratified this particular decision in an open meeting. By the way, this is a completely different scenario. So in scenario one, goes to your question, the DRE ruled those were not official records of the association that need to be disclosed because there's no decision being made, which frankly surprised us a little bit. But in scenario number two, this one, new one, is an open records meeting violation. So now the same homeowner sues the association in the Department of Real Estate, claiming there's an open meeting violation because they didn't make this decision in an open meeting, but via action in lieu with unanimous written consent. In that DRE matter, the judge held there was a violation of the open meeting law and sanctioned the association like $2,500, even though they ratified and open. Other judges may not say that, but that just goes to open meeting laws, a different topic entirely. I should have a class on that, similar to this with open meeting law stuff. If you want to do that, give me a thumbs up. But yeah, as far as email communications with no decision, the DRE judges are leaning towards those not being association records required to be disclosed. What happens if the percentage of mandatory owners do not respond to the request for an amending CC&Rs or other community documents? Okay, Donna, that's a question you can ask me offline because we can go through that. Can a current owner request the violations of the previous owner of the home? That's a good one. So new owner, same home. I'm going to presume when they purchased the property, the disclosure that you have to provide as the management company said that there were violations. And because the prior owner had gotten a bunch of violations, we're going to do two scenarios. This is scenario one. And then once they close on the home, you send them another letter saying, hey, you got to clean up these problems and cure them. Otherwise, we're going to kick you off to the attorney. They respond to you and say, hey, give me all the violation history for this home. You have to give it to them? Yeah, I think you do. They're the owner. It's a violation history that involves them. They step into the shoes of the prior owner. So that's scenario one where there's an ongoing violation. The bigger question comes to violation, the scenario number two, where there was a prior violation. It was completely cured. You have a closing of the house. So there in the disclosures, there's, hey, everything's clean. There's no violations. And then the new owner says, I want all the violation history of the prior owner, even though it's totally irrelevant to that new owner. I think arguably they're not entitled to that. It's personal information of the prior owner. If they want it, they should go to the prior owner and get it from them or get the prior owner's approval because it has nothing to do with them and it's not relevant to them at all. If, however, any of those violations would be relevant to a pending violation, I think they have the right to grab those violation records. That's a good question. All righty. Well, fantastic. I think there's a couple of other questions I'm probably missing. Please reach out to me direct. We've got to end now, but if you have questions that I didn't answer, didn't see in the chat, number one, I apologize. They either may be relevant to this conversation or they may not be, or I just flat out missed them because of the time and all the questions that are being asked. So please feel free to reach out to me direct. If you don't have my email, it's clint@goodlaw.legal. If you've got my cell phone or call me, that's fine. I'm available most of the afternoon. Give me a call and we can go from there. Okay. Well, thank you. Just so you know, Christy will be tabulating all of the results and we'll be emailing all of the managers that won a lottery ticket. Well, I don't think anyone stumped me really, unless you guys agree. If you guys agree, somebody stumped me in these questions, text Christy or chat Christy and let her know. And we'll get them a Powerball ticket. But otherwise, as far as those of you who answered the majority of these questions correctly, we'll make sure we get you your scratcher's ticket. Thank you so much for joining us. I hope each of you learned something. It's been a pleasure being with you today. Thank you. Bye-bye.